ELL case law began with the United States Constitution. More specifically, the First Amendment, freedom of speech, and the 14th Amendment, the Due Process Clause. Lawyers and legal scholars were enabled by these amendments to fight for the rights of English language learners. In 1919, Nebraska enacted the Simmon Act, which stated that no foreign language could be taught in private or public school. Only English may be taught in school. This prompted the case Meyer versus the State of Nebraska. Robert Meyer was convicted under the Simmon Act for teaching his student German. The case made it to the Supreme Court of the United States. In 1923, with a vote of 7-2, the Supreme Court supported Meyer and deemed the Simmon Act unethical. The liberty protected by the Due Process Clause included teaching in and learning foreign languages. That the state may do much, go very far indeed, in order to improve the quality of its citizens physically, mentally, and morally is clear. But the individual has certain fundamental rights which must be respected. The protection of the Constitution extends to us all, to those who speak other languages, as well as to those born with English on the tongue. Perhaps it would be highly advantageous if all had ready understanding of our ordinary speech, but this cannot be coerced by methods which conflict with the Constitution. A desirable end cannot be promoted by prohibited means. Justice James Clark McReynolds, quoted from the majority opinion of the court. It was a monumental victory that paved the way for new legislation concerning ELLs. But it wouldn't be until 1964 that new legislation came about. The work done by civil rights leaders like Martin Luther King Jr. prompted the creation of the Civil Rights Act. Specifically, Title VI of the Act stated that no one can be discriminated against or excluded from any federally funded program based on his or her race, color, and national origin. Finally, the people found their voice. 6 years later, on May 25, 1970, the Department of Education passed the Department of Education Memorandum. This particular memorandum directed school districts to help limited English students develop language proficiency in order to meaningfully participate in the regular curriculum. However, there was no way to hold school districts accountable for serving or not serving English language learners. In that same year, Diaz, Rico, and Weed reported that the Office of Civil Rights required schools with more than 5% national origin minority children to provide some type of specialized instruction in the English language for non-native speakers. This paved the way for federal courts to further enforce Title VI. In 1972, a federal judge ordered native language support as part of a desegregation plan in Siena v. Portales Municipal Schools. The decision in Siena v. Portales Municipal Schools led to the decision made in Lau v. Nichols of 1974. Roughly 1,800 Chinese students in the San Francisco School District lacked basic English skills and were denied access to fair and appropriate school instruction. The U.S. Supreme Court decided that basic English skills are at the very core of what these public schools teach. Imposition of a requirement that before a child can effectively participate in the educational program, he must already have acquired those basic skills is to make a mockery of public education. Finally, it was clear. School districts cannot deny the education of children who have limited English or no English skills. Lau v. Nichols established a precedence for Mexican-American parents to sue Raymondville Independent School District in 1978. The parents claimed that the school district was not providing appropriate assistance to help their kids overcome the barriers of English. This prevented equitable access to school programs for the children. However, the courts ruled in favor of the Texas school district. The Fifth Circuit Court of Appeals overturned that 1978 decision. It ruled that schools must provide adequate and appropriate instruction, and the instruction must meet 3 criteria. First, the program must be made on accepted educational theory. Second, the program must provide adequate resources and personnel. And third, the program must be evaluated and adequately monitored to ensure any necessary modifications. 2 other decisions helped improve English language learner rights. The U.S. Supreme Court ruled in Plyer v. Doe that any alien, even if illegal, are recognized as persons, and as people, they are guaranteed due process under the 5th and 14th Amendments of the United States. That means that schools and education officials cannot act as agents of Customs and Border Patrol, and they cannot deny enrollment to these students since the schools receive federal funding. And finally, the No Child Left Behind Act. No Child Left Behind propelled English language learner education into the national spotlight. George W. Bush signed No Child Left Behind into law in 2002. No Child Left Behind held school districts responsible for the education of all of their children. Special needs, English language learners, accommodations, modifications, every student's education must be upheld. Since 1964's Title VI, no legislation held school districts responsible or placed them to ensure that they were providing adequate education to English language learners. School districts, personnel, and teachers are finally responsible for teaching, monitoring, and reporting the growth of English language learners and limited English students. This gave rise to new laws in Pennsylvania. First, a newly enrolled student must complete a home language survey. The Pennsylvania Department of Education uses the home language survey to determine if a child is float, that is primary home language other than English. If a child is float, they will receive ESL instruction. There are exceptions to instruction. If a portion of ESL instruction conflicts with religious beliefs, parents may submit in writing an excusal to remove the child from that portion of instruction. They may not be excused from the whole ESL program. Or, the child meets at least 2 out of 3 of the following criteria. 1. Their final grades are B or better in core subject areas: math, language arts, science, and social studies. 2. Their scores on a district-wide assessment are equivalent to basic on the PSSA. 3. Their scores of basic in reading, writing, and math on the PSSA or equivalent assessment from another state. Is parent permission required to assess for ESL services? No. By completing the home language survey, parents agree in Pennsylvania a child can be assessed for ESL services based on their responses to the questions. Can any certified teacher provide ESL instruction? No. To provide ESL instruction, one must be certified to teach ESL. However, classroom teachers and others can support the ELL in their classroom using linguistic modifications, visual supports, and alternative teaching strategies. Are the hours of ESL instruction equal to the level of English language proficiency? Yes. The least proficient ELL students receive 2 hours of ESL instruction from an ESL teacher each week. The more proficient, the less instruction. Are ELL students graded using the same grading system as all other students? Yes. PA requires that ELL students be graded using the same system as all other students. Can ELLs be retained a grade level if their English does not improve at least 1 level? Simply put, no, they cannot. Are the Pennsylvania English Language Proficiency Standards designed to be used solely by the ESL teacher? No, they're not. The ELPS are designed to be used by both the ELL teacher and the classroom teacher to inform and design instruction. Do parents of ELLs need to be informed about their child's progress? Yes. Parents need to be updated about their child's academic progress. And that's why you're here. Integrity, civility, responsibility. We have a responsibility to abide by the laws of the United States, to educate all children of our country, to promote growth for all students, and finally, to learn how to accommodate our ELL students. Thank you.